All right. Good evening, all. I hope you all are doing great. Welcome back to the live streaming of the daily news analysis with your educator Prithviraj Singh. And today we'll be understanding the important news articles of 23rd July 22. Now, this session, these series, the series that we are coming up with for the live streaming of the newspaper analysis are very important for all the students preparing for UPSC, state services, and the law examination. So So we break the live stories on a daily basis at around 5 p.m., 5:15 p.m. And I'm your educator, Prithviraj Singh. Let us begin with the session. Well, recently we all have come across the Supreme Court bail, issuance of bail for Mohammad Zubair. Mohammad Zubair, who was the co-founder of Alt News company, and it was being alleged by the government that he was, tweeting some posts which result into communal disharmony and it hurts the religious sentiments of the people. He was issued some sections and he was slapped by certain sections in IPC and he was being arrested. The case went to Supreme Court and the court gave him bail order. Now, the moment he got bail order, he was being again, slapped with a new FIR. Then again, a bail was issued by the court. Then a new FIR came. So, in this sense, multiple FIRs were being filed against Mohammad Zubair to ensure that he remains in the jail. Now, many liberal thinkers in India have said that this is a jail jurisprudence which is being, displayed by the executive, and executive is overpowering its presence uh, in the I mean, it is intercrossing into the domain of judiciary. So over this in this backdrop, we'll try understanding what is bail, what is arrest warrant, and if at all there are any reforms which are required in the bail law. Now, beginning with the article which appeared in today's Hindu. Now, it starts with a recent judgment of the Supreme Court, Satyendra Kumar Antil versus CBI. Now, in Satyendra Kumar Antil versus CBI, the Apex Court has issued fresh guidelines on arrests in order to have strict compliance with the provisions of 4141A of CRPC 97. Now, before I explain into what is Satyendra Kumar Antil versus CBI case, we should have a basic understanding of bail. What is bail? What is an arrest warrant? What is anticipatory bail? Right. So, a bail, students, is nothing but an amount of money that a person pays, who has been accused of a crime. So a money it is amount of money is being paid by a person who is being accused of a crime, and he pays to the law court, right, so that he can be released until their trial. So see, because until your trial takes place, you are being detained into the police custody, right? So there is a detention that you have to serve till your trial is being processed, right? So to avoid this pre-trial detention, people generally pay some amount, also called as bail bond, and on this bail bond they are being set free on the promise that when the trial begins, they have to appear in the court of law, right? So in this sense, it is a amount that accused person pays, to a law court so that he can be released until their trial. Now, the payment is a way of making certain that the person will return to the court for trial rights. So, in this sense, it acts as a bond, right? And this ensures, and it's a contract definitely. You are to supposed to present before the court of law when your trial takes place, and if you don't appear, then the penalties and a new offense, you would attract a new offense, which is again mentioned in IPC as well as CRPC, right? The person who does not appear, when called so, and who is being set free, for the bail orders, if it doesn't, appears, turns up, then also it is a offense. Number one. Number two, if the suspect returns, to make all the required appearances when, as and when called by the court of law, the bail is returned. So whatever bond that is you have given is returned after the trial is concluded, right? So in this sense, for example, you might have come across some statements like so and so person is being released on bail of, let's say, 1 lakh rupees or $1 lakh, so on and so forth. So in this sense, it is a promise, done by the person to appear in the court when required. So this is called as bail, right? Now, talking about anticipatory bail. Now, anticipatory bail is a bail granted to a person in anticipation and apprehending arrest. Now, there are times, and generally it happens because these days there is vendetta politics, politics of vengeance, and also even not in politics, there are many, family disputes and corporate disputes, and people generally file cases against each other, right? So it has been seen that sometimes influential people try to implicate their rivals in false cases, right? So they try to implicate their rivals in false cases for the purpose of disgracing them, right? Because once a charge is being, cooked or slapped against you, you would be detained by the police, and then you may have to serve the jail sentence. Getting my point? If it is a crime, right? And this comes as a disgrace, and a guilt for the person, living in the society, right? So just to disgrace somebody, you know, influential people, try to implicate their rivals in false cases and for other purposes by getting them detained in jail for some days. Right? And this actually, dents their image, and also, dents the image of the organization in which they are working, right? So when to actually avoid such vengeance and vendetta, a provision is being given in CRPC 1973. Although it was not originally included, it was later inserted. It was inserted only, with the passage of time. Now, anticipatory bail in this sense, as the name suggests, anticipatory. So, in anticipation of a arrest. So, in anticipation of an arrest, the accused person, issues an anticipatory bail, so that he may not be, called or detained, or put behind the bars uh, until the trial starts. So, anticipatory bail is a bail granted to a person in anticipation and apprehending arrest. So, in this sense, it is a preventive relief, which was not originally in the CRPC. The very purpose for the provisions relating to anticipatory bail is to ensure that no person is confined in any way until and unless held guilty. Right. So in this sense, it protects the person's liberty and ensures that no person is confined in any way until and unless he or she is being held guilty. Right. So this is the anticipatory bail, and now now we must also understand what is arrest. See, arrest is nothing. It is something which prevents your liberty. Right? An arrested person has very limited, rights to be, enjoyed, because he or she may not enjoy the fundamental rights which are being given for, which are being availed by a normal person, right? So and so therefore, arrest puts a limitation on the enjoyment of the rights. Right? Now, before you are being arrested, I mean, there are definitely cognizable and non-cognizable offenses. For some, arrest warrant is required, and for the other, the arrest warrant may not be required, right? So, an arrest warrant itself is a contract, is a warrant issued by a judge or magistrate on behalf of the state, right? So they may, on behalf of the state, means a judge or a magistrate may issue a arrest warrant, and it may be, excised by the constable or a police officer or a sheriff or sheriff, and this warrant authorizes the arrest and detention of an individual or the search and seizure of an individual's property. So in this sense, it is nothing but an act of authorization. It gives authority to a person, majorly constables, police officers, to arrest a person, right? And it is usually issued by judge or magistrate that permits an otherwise illegal act that would violate individuals' rights and offers the person executing the writ protection from damages, right? So in this sense, it authorizes the arrest and detention of an individual. Now we are clear with what is arrest warrant, what is anticipatory bail, and what we understand from the meaning of bail, right? Now, what the state is set to understand this article. Now, after Mohammed Zubair case, which who has recently been, set free by the apex court on the bail orders, and a case recently appeared, on July 11th this month, Satyendra Kumar Anthil versus CBI. Now, because the bail is being used, for the vested interest, so therefore the court issued some fresh guidelines on the arrests in order to have strict compliance, with provisions of Section 41 and 41A of CRPC 1973. So CRPC 1973 provides all the laws for the which are there in the commissioning of a crime, and what all things would come into it. So in Satyendra Kumar Anthil versus CBI, the court has issued fresh guidelines, and they've said that Section 4, the orders, the arrest orders must have strict compliance with the provisions of Section 41 and 41A. Now let us understand what is 41 and 41A. Well, 41 of CRPC provides for circumstances in which arrest can be made by police without a warrant. Right? So there are many circumstances where the arrest can be made by the police without issuing any arrest warrant. Right? Although Section 41, mandates for reasons to be recorded in writing for every arrest and non-arrest. Right? So that means the reasons must be recorded in writing for every arrest and non-arrest. The reasons must be recorded, but then there is no issuance or mandatory issuance of arrest warrant, right, under Section 41. Now, 41A, on the other hand, says that a notice has to be sent by the investigating agencies before making an arrest in certain conditions prescribed by the code. That in this sense, it says that a notice has to be sent by the investigating agencies before making an arrest. That means the person should be made aware about his arrest, and that the notice must be sent by the investigating agencies, in certain conditions prescribed by the code. So in Satyendra Kumar Anthil versus CBI, the court says that the ethics court says that all the courts will have to satisfy themselves on the compliance of Section 41 and 41A. Correct. That means all the courts have to comply with Section 41 and 41A. Getting my point? And any non-compliance of these two sections would entitle the accused for grant of bail. Right? In this sense, if any court or authority, the investigating authority, does not comply with Section 41 and Section 41A, then it is a valid ground for the accused to be granted bail. Right? So in this sense, it is an indication for a reform in the bail law. Now, in another case, in Anish Kumar versus State of Bihar 2014, the court said laid down the same things. Right. At the same time, the apex court in Satyendra Kumar versus CBI also said that a separate legislation on bail law is the need of the time, because there has been hasty and indiscriminate arrests, and there has been delay in the bails and the plight of under trial prisoners. Because When a person is arrested, as said in Joginder Kumar 1994 verdict, the court apex court said that the reputation and self-esteem of a person, you know, is harmed because when a person is put behind bars, his reputation and self-esteem is hit. He faces humiliation, and it curtails freedom and casts scars forever. So therefore, uh, the reform is being required in the bail laws. Right? In in Satyendra Kumar Antil case, the court has issued specific directions and has also called for a compliance report. Now, we have discussed about Section 41 and 41A and how their non-compliance would entitle the accused for grant of bail. Well, the government of India may consider the introduction of a separate act, a separate bail law, which would actually, decide would come up with all the provisions of the bail. It's the nature of the bail, so as to streamline the grant of bails. Because today we do have the sections in CRPC and IPC, which actually governs the bail, but we don't have a concrete law, which would talk about the bail. There need not be any insistence on a bail application while considering the application under Section 88, 170, so on and so forth. Now, again, recently in the previous year, Siddharth versus State of Uttar Pradesh 2021, the apex court said that the bail applications ought to be disposed of within a period of 2 weeks, except if the provisions mandate otherwise. In this sense, the bail applications, what if any accused person who has filed an bail application, his application must be disposed of within a period of 2 weeks. So this was being held in Siddharth versus State of Uttar Pradesh. And in this case, the apex court also said that applications for anticipatory bail are expected to be disposed of within a period of 6 weeks, you know, uh, with the exception of any intervening application. For example, if a person has, because there is no time frame, to for the bail to be granted, right? And that is the reason why it has been misused. However, in the judgments in Siddharth versus State of Uttar Pradesh, the apex court has laid down some guidelines, like for the bail applications, the normal bail application must be disposed of within 2 weeks, and the anticipatory bail applications must be disposed of within 6 weeks. Right, 6 weeks is 1.5 months. At the same time, in Satyendra Kumar versus CBI, the court also talked about the constitution of special courts, and these courts would actually, these special courts would actually, adjudicate over the bail orders. The CGI has also raised the issue of vacant positions and infrastructure requirements in the judiciary. Now, the high courts have been directed by the apex court to identify under trial prisoners who cannot comply with bail condition, because there have been many under trial prisoners who are not in the position to comply with the bail conditions, and majorly the poor, the destitutes are the one who face the the bad condition that they face in jail, and they are not able to avail the bail, bail as a provision. Right? Even Section 440 of the CRPC says that the amount of bond shall not be excessive, and high courts and session courts may reduce the amount prescribed by the magistrate or a police officer. Now, Section 436A of the code, under which a person imprisoned during investigation or trial shall be released on bail on completion of half of the jail term prescribed for that offense. So, in this sense, this article talks about the bail law, the bail reform. A new law must be passed by as said by the author, be passed by the parliament. And we must note about Satyendra Kumar Antil versus CBI, Section 4141A CRPC, and how their own non-compliance would attract, would entitle the accused for a grant of bail. So, so this is an important case which I want to discuss. As said by the apex court, that the anticipatory bail should not be more than 8 weeks. Every arrest must be in accordance with the procedure established by law, so on and so forth. Now, again, an article appeared at the editorial section about the reforms in the bail law, and it said the authors explored that before you reform the bail law, make the right diagnosis first. Now, it starts with expounding that over 75% of India's prison population are under trials. While, so in this sense, you know, out of the total prisoners, in the jail, 75% of them are under trial. That means their trials have not been completed, finished. They have not been, their punishment have not been decided, or they may not have been acquitted, right? So no decision has been arrived. Getting a point. So they are still under trial. And out of the total prisoners in the jail at present, 75% are under trials. So that is a shocking reality. And the jails in India are overcrowded. And this for the percentage stands at 118%, 118%. Right? So this actually explores the crisis in India's criminal justice system. And the same was also explored in Satyendra Kumar Antil versus CBI. It said that the ineffectiveness of India's bail system and its contribution its contribution to this crisis. Right? So there is an ineffective, bail system in India. Now the authors are saying that uh, uh, the timeline for disposal of the bail applications need to be laid down, and it is also rightly being laid down in Satyendra Kumar Antil also, and also in the recent case by Siddharth versus State of Uttar Pradesh 2021. Right. So these are the two important cases for the bail or reforms in the bail. Now, this says that a mandatory timeline must be set for disposing of bail applications and laying emphasis on the need to enact a separate legislation. Right. Now, it says that because if you don't do so, then the principle of presumption of innocence, because when an accused is being called before the court of law, it's being, the judge, it's being presumed that the person is innocent, right? So the principle of presumption of innocence is being followed by the court of law uh, until unless the judgment has not arrived, right? So for accused person, he or she is always innocent till the decision is not being arrived by the judges, and that bail, not jail, should be the norm. So that is the reason why bail jurisprudence or bail as a law in CRPC was being inserted. Right? Although it was not there in the original CRPC, but then it was inserted later. I'm talking about the anticipatory bail. So the principles of presumption of innocence and the bail not jail should be the norm. So these principles also, falls falls back if we do not have a proper bail law. There are large scale under trial incarceration, and we must, because there are many studies which are being done in the jail, and it's being found that 18.5% of the prisoners are migrants, 93% did not own any assent, so they are the destitutes, the poor among the Indian society, and 62% did not have any contact with family. So that is the reason why, and it's being seen that the influential people, the people with muscle and money power, with political contacts, are the one who do get the bail orders. So therefore, the law must be made by the legislature to reform it and to make it more transparent, accountable, and equitable. Now, what proportion of under trials are applying for bail? What proportion of bail applications are accepted or rejected? And on what grounds? Is bail compliance a far bigger problem than denial of bail? So these are the questions which are being explored in Satyendra Kumar Anthil versus CBI. The court also explored that the foundation of the current bail law ensures that it is anti-poor and disproportionately burdens those from marginalized backgrounds. So the author explores that the current bail law is anti-poor. It doesn't, come to an advantage to the poor people. And and the fact is that 18% of the prisoners are migrants, 93% do not own any assets, right? So in this sense, it is biased. It disproportionately proportionately burdens those from marginalized backgrounds. When the court averred that effective enforcement of safeguards against arbitrary arrests would eliminate the need to seek the bail orders. Right? The court averred that effective enforcement of safeguards against the arbitrary arrest, because you've seen there are many arbitrary arrests, right? And this actually, dents the image of the person. And if you have enforcement proper safeguards, it would actually, in place, then against the arbitrary arrest, it would eliminate the need to seek bail from the courts. Now, the arrest of a person is justified as necessary if the police have reasons to believe that it is required to ensure their presence in court. So, in this way, this article, raises the issue of reforming the bail law, and this is something which has to be read by every student here. And this is how some facts about the judicial system. In fact, the criminal judicial system. Now, the question comes that, do we have the protection against an arbitrary arrest or indiscriminate arrest? Well, there are some fundamental rights which protect a person from indiscriminate arrest, like Article 20. We all know Article 20 is protection against indiscriminate arrest, and by stating that no person shall be convicted of any offense except for violation of the law enforced at time of the commission of the act charged as an offense, right? Nor be subject to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offense. So Article 20 provides for protection against indiscriminate arrest. Then you have Article 21, which is the right to life and personal liberty. That means no person shall be arrested or no person shall be deprived of his life and liberty except for the procedure established by law. Again, it is a fundamental right. Article 22 provides protection against arrest and detention. That means it is a right of every person to know, the ground of arrest, and such person, the accused person, has every right to consult and be defended by a legal practitioner of his or her choice. And the accused person, should be produced before a magistrate within 24 hours. And this is also called a writ of habeas corpus. That means the detained person must be produced before the court of law within 24 hours, excluding the journey time and the holidays, the listed holidays, national holidays. And if it's not been produced, then definitely he can sue the court. And so it is a protection of his liberties. So these are the articles which actually protect an individual against indiscriminate arrests. So in this way, today we explored about the bail law and why there has been talks about reforming the bail law, the very bad situation of Indian prison system, Indian criminal justice system, and moving ahead. Well, an article also appeared in the newspaper about setting up a Supreme Court collegium, and this collegium, I mean, Supreme Court collegium is already there, and recently the collegium has recommended 35 names for the judges in 6 high courts, right? Now, let us discuss what is collegium and how it functions and how it plays an important role in the appointment of judges in High Court and the Supreme Court. Well, this issue appeared in the year 1993, also called a second judge's case. Now, here Supreme Court introduced a collegium system, holding that consultation really meant concurrence, because the original Constitution says that the president must be consulted, right? So my bad. The president must consult the CGI while appointing the judges of the courts. So, is this consultation a concurrence? That means, is the advice tendered by the Chief Justice of Supreme Court is binding on president or not? So, this question actually, was being explored in second judge's case, and it was being held that the consultation really means concurrence. That means the advice tendered by the Chief Justice of India to President in the appointment of the judges is binding on him. Now, this case also added that it was not the Chief Justice of India's individual opinion, but an institutional opinion formed in consultation with the two senior most judges in the Supreme Court. So, in this sense, it formed a collegium of two senior most judges of Supreme Court, headed by the Chief Justice of India. Right? So, these are the two Supreme Court senior most judges of Supreme Court who would advise the Chief Justice of India, in appointment of the Supreme Court judges and the High Court judges. And the advice tendered by the CGI to President is binding on the President. So, this was something which was being declared in second judge's case. Now, in the third judge's case, 1998, the court, Apex Court on President's reference, expanded the collegium to a five-member body. So earlier it was a two-member body. Now it became a five-member body. It comprises of four senior most judges of the Supreme Court, headed by the Chief Justice of India. Now, so in this sense, it became more democratic in nature and more, diverse. The Supreme Court Collegium is being headed by Chief Justice and comprises four other senior most judges of the court, as we just mentioned. A High Court Collegium is led by its Chief Justice and four other senior most judges of that court. Right. So, in this sense, the High Court Collegium is led by its Chief Justice and four other senior most judges of that court. That means whenever appointment to the High Court judges is to be made, I'm talking about the district appointment district judges. A High Court collegium would be led by the Chief Justice of the High Court and the four other senior most judges of that court. So today we are following the same process, the third judge's case of 1998. Now, as far as the appointment of CGI is concerned, the President of India appoints the CGI, and CGI is the senior most judge of the Supreme Court. As far as the CGI is concerned, the outgoing CGI recommends his successor. Right? So this is a practice which has been followed, and in practice, it has been strictly by seniority ever since the supersession of controversy of 1970. So there have been only two instances where the seniority principle was being, surpassed. Now, for Supreme Court judges, the proposal is initiated by the Chief Justice of India, and then it takes the advice. He takes the advice of the four senior most judges of the court, and this collegium actually, is in performs its function for the appointment of the Supreme Court judges and the High Court judges. Right. So, and as far as the constitutional provisions are mentioned, Article 124, Clause 2, talks about Indian Constitution on and the appointment of two judges of Supreme Court appointed by the President after consultation. So this consultation is concurrence as held by the second judge's case. So guys, that's all for today. I hope you enjoyed the session. Today we discussed about important details about the bail law and how it has to be, how it will. There are talks going up to reform it. We talked about Satyendra Kumar Anthil versus CBI case, and we also discussed the collegium system. That's all for today. Do like, subscribe, and comment for any queries, and we would be more than happy to address all your questions. That's all from my side. Wish you all the best. Good day. Goodbye. God bless.